Yes. Okay. Well, why don't we get started? Carol may join and Lynn will get set up in her office. Yeah, so you got the documents that we circulated. I think we had a few specific questions that we wanted to get to today that accompanied those documents. I'll just review them real quickly now, and then I'll turn things over to Kate to kind of review the documents in general, but hopefully we can get to each of these questions and then think about things going forward. First being, and Kate, you can do these in whatever order you'd like, or if you've got additional questions, certainly. But the ones that we put out, do we think that something should still be required in the area of negotiation? And if so, what? And then the proposed timeline tries to strike a balance between giving applicants enough time to complete the portfolio, but also enough time to change the submissions or adjust them as a result of feedback they get on them, and with enough time to decide to take the bar exam. And do we have the right balance there? And should we specifically be requiring more work sooner in the portfolio? And third, what about the application process, and how is eligibility determined for part-time students? And then what does the fee structure look like? And then, of course, we wanted to get specific feedback from AJ and Tom. Emily can't be here, as we said, on the proposed timeline and process. So, pretty full agenda. Kate, I thought we'd turn things over to you, talk about the documents, and obviously if there's other issues you want to get to, and I'll try to keep us on task.
Yeah, thanks. I mean, I guess the one, so here's where I see us in the process. I feel like we've done a really good job, in terms of our coming to consensus and adjusting to the feedback we've gotten from the larger part of this subcommittee on the contents of the portfolio and thinking that through. We'd begun to talk about the process for applying last time, and what I did in the interim was just thought, if I'm an applicant, and then Emily had floated the idea that maybe what would be happening from the board of law examiners end was maybe they would be setting up these quarterly, like kind of grading, reviewing windows, which is similar to what we heard Debbie Merritt describe that they do in Oregon. So just kind of working with that information, I tried to plot out a vision of what it would look like for people to go through this process, both in terms of taking the classes that they would need to take, the credits that they would need to get from what we'd said were curricular requirements, how many opportunities they'd have to take the MPRE, because we said that would still be required, where those opportunities would come in. So thought about a quarterly timing for submissions, like what that might look like, and kind of starting with, I think I said like February, April, July, October. I don't know, now I'm trying to do it without looking at it, but thinking again, like February, July, kind of thinking about the bar exam as well, and kind of using those and then adding a couple more in there, and then so and then circulated that and got feedback from Emily and Carol, and so I guess it's just like looking at that timeline and using that as a point of discussion. I put in this curricular pathways, kind of summary document, a little overview in eligibility and timing in the overview section. My vision would be after we finish talking about it and kind of hammering out the details, using this timeline as sort of a tool for doing that the next step would be writing just like there's a more detailed section on more detail on the contents of the portfolio, there would be a more detailed description of the application and review assessment process that would be part of the report. So that's kind of where we are, is trying to decide, hammer out the details so that we can write up a more detailed part of the report. And then I think all of that would be a good thing to then be bringing in a couple weeks or whatever, when we're bringing this to the full group. So that's my, so in terms of the specific questions, I think there's a couple small ones. One is eligibility for part-time students. And what I put in the overview, what I did was I looked back at the rule that we already have about student practice, which says that to be eligible for the student practice rule, students have to have completed the equivalent of 2 semesters of legal study. So I just took that language from our supervised practice rule and sort of incorporated that into the eligibility for this pathway. I'm not necessarily saying that you would have to be under the student practice rule to complete the work, but it seemed like a good way of equalizing kind of part-time and full-time students in terms of where they are in their legal study, and also not reinventing the wheel, like using a construct that we already have in our rules. I don't know if anyone has feedback on that. I feel like Mitchell Hamlin is probably the school that's most affected by that. And I don't know if Lynn in particular has any feedback on how that works in terms of certifying students for student practice. Maybe she's still.
Yeah, I agree with you, Kate. As long, I wonder if it's, I guess I don't know, and AJ, maybe you know, because I do student practice certification outside of Minnesota, but does 2 semesters mean 2 semesters regardless of the number of credits? Is it just time spent? Or maybe Kate, do you know?
It's the equivalent of 2 semesters. I think that usually means 28 credits.
So like 2 full-time semesters is what that means in practice. I guess I don't, other states will list like you have to complete 1/3 of the required credits for graduation or certain courses. And so I never really understood what the definition of the equivalent of 2 semesters means, because I haven't had to apply that.
I don't know. I don't do much with student practice. I do know that Emily has on her to-do list for a long time we should revise the student practice rules, because a lot of these standards are kind of vague, and we, like to Lynn's point, like it's just kind of, they're old, and when COVID happened, we had to add supervised post-graduation. We just kind of copied, pasted, and just did it really fast to get it in place for COVID. But the standards aren't the clearest, and so I would guess that it does mean the equivalent of 2 full-time semesters. And you two would know credits better than I do, but I don't know that for sure. Emily probably would.
Yeah, and that may be
backing up, just maybe I know better than other people then, in terms of Mitchell Hamlin, because for students to sign up for a clinic, I think we usually say that they do the student practice certifications, we say they need 28 credits, because that's the equivalent of 2 semesters at Mitchell Hamlin of full-time study.
Yeah, and I think whatever it is under the student practice rule, I think we can clarify that and make that clear in this rule. And I think that is, I guess, fundamentally, I think that's a good construct, and I just don't want to be the one to say what that means today. I could figure that out, or as a group we could figure that out, but I think that concept makes total sense.
Mm-hmm.
So I think we should track the student practice rule just to stay consistent, so we don't have, like, in the state of Minnesota for law students, like one thing for student practice and a different thing for the pathway. I mean, it just feels, I'm all for simplicity.
Yep.
And not having.
Well, and then and maybe we just say something like that. Could we say eligible students are those eligible for student practice or something, so that if the rule changes, then we don't have to go back and say 28 credits if somehow the rule goes to 22 or whatever.
That makes sense to me.
Yeah.
It also says it must apply by January 1st of their second year of law school. I think that that would be after 3 semesters for everybody. So I think that wouldn't be a problem.
So would we say
Agreed.
something
And then
like
they
that?
would have all the classes they missed, right? Like, or CDR in particular at Mitchell Hamlin would be included in that third semester for part-time students. And so that's, I think, a key civil procedure. That's a key
Mhm.
course.
Yeah. So the other kind of hanging question was the negotiation. So I think Emily had said, wait, what did we decide about that? So I thought, oh, maybe I thought we had just decided not to require, certainly we had decided not to require a supervised, any assessed performance in a negotiation by a student. I think we had left open whether or not or I thought we had decided, we discussed briefly like whether or not we should replace that with a curricular requirement that students take a course in negotiation. I think what I heard at the last meeting at Mitchell Hammond, this is like already a graduation requirement for students. Like they have to either take a class called negotiation or they have to take a simulation course that focuses on negotiation called transactions and settlements. So I would think that at Mitchell Hammond, this would be unproblematic, but I understood from hearing from the other schools that maybe that those opportunities wouldn't be quite as available to students. So I just wanted to hear back, I guess, from Ben and Steve and Carol about whether or not we want to include that or not.
Yeah.
So
Ben,
this is Carol.
oh, hey, Carol.
Hello. I managed to call in a little bit late. So Steve can answer that part of the question better. My sense is that it's certainly not a requirement, and I think it might be a problem to require it. The other idea that was, I think, floated in maybe just between you and me, Kate, I don't know, is doing something like the PR piece of a journal entry or 2 journal entries having observed a negotiation, because I think they're all, and I think we'd have to describe it more so that it doesn't mean it's a full-fledged negotiation and with negotiating a settlement. There are lots of other kinds of negotiations, but that could be another way to include it somewhat and then define a bit what kind of questions should be answered. I mean, basically learning about negotiating skill and talking about it in a journal entry. And the other comment I wanted to add here is in the meeting yesterday with the supervised practice folks, it became one of the things that we started to talk about a little bit was the possible differences between the 2 pathways and how to explain them. So negotiation could more easily be included in the supervised practice pathway because those will be people who are out doing law in the real world after graduation, and they may have opportunities the way they do in Oregon, although it's not totally unproblematic. But if there were not a requirement for negotiation at all in curricular pathway, and there is a negotiation requirement on the supervised practice pathway, then we need some kind of explanation of why you can be licensed without that on one pathway and with it on the other one, which might suggest including it somehow. And the journaling piece would be a way to do it that would be more possible, I think, for everybody who wants to participate than requiring a negotiation course. I don't, I'm not saying that's the way we should go on it, but I wanted to bring that other idea in because it came up as we started to talk yesterday about supervised practice pathway.
Yeah, I think that's a really good point, Carol, about the, trying to keep the pathways as they're developing, keep them consistent. I wonder whether or not it would actually be easier just to take a class than to reflect on something you observed. I'm not sure how students who are in an externship or in an employment setting would get permission to observe a negotiation. I mean, it just feels like a big ask of their supervisors, and it just feels like a big ask as opposed to. And then if they haven't had a negotiation class, I don't know how their reflection is going to be informed by the principles underlying negotiation theory. So it almost feels like that is like saying take a negotiation class plus find a negotiation you can observe and then reflect on it. And anyway, I feel like that has some of the same logistical problems as asking them to do it. But I wonder, we are saying take 9 credits of clinics or field placements. We could say 15 experiential credits, 9 of which have to be in clinics or field placements, and 3 of which have to be, or 2 of which, at least 2 of which have to be, depending on what credits, have to be in a class that teaches the skills, focused on an experiential class that teaches the skills of negotiation, or we could say mediation or alternative dispute resolution, because I think a lot of those same underlying principles are taught in ADR and negotiation and mediation courses. And I wonder whether or not, like, if we broaden that, whether there'd be enough opportunities for a student on the pathway to sign up for a class like that.
Yeah.
Yeah.
Kate, to the question, that would be really limiting at St. Thomas from a curricular standpoint. I was just looking, we only offered 1 course last year on negotiations, and it was adjunct taught. It had 14 students. We had a negotiations team, but we would need to expand that. Your point is good, though. There might be some other spots to get that in an ADR course or something as well. But from just a pure negotiations course, we don't have any spots for students.
Yeah, and at the U, it's interesting. It's certainly not a requirement. We've got a couple of upper level courses, a couple taught by adjuncts, and then one faculty member who's also on the faculty of the business school. But the other thing I don't know, I should have found out about this, Carol, you may know, but as part of the law and practice curriculum, which is required of every first year student, there may indeed be a negotiation or mediation aspect of that, the simulation, of course. But if it, that could be something that would count towards this, if we're going to make it a requirement. Maybe they have to do an extra reflection on it. I don't know. I mean, if I could find out what.
Yeah, I do think there is some kind of negotiation component, but my vague memory is that some students participate directly, others observe other students, but reflect on it and talk about it. So I think it could qualify. I think we need to learn more about that. And we might want to see whether there are other, like John Matheson's contracts class, he has people do I think, at some point, well, no, maybe he's doing a complaint and answer, but I think there may be other courses that have enough of a component of negotiation. So it's not a course, a single course that everybody would have to take on negotiating, but that some of the principles of negotiating are included. I also wonder about creating, this would be totally different, and it's just an idea floating in my head, but not necessarily something we want to pursue on this or anything else, is a module of reading, and then they reflect on it, so that, because Kate's comment about they might not have the background. I mean, we did a day, in my contracts class years ago, Maury Lansman and I did a day where we did, we set some groundwork on negotiation, but not very much, and set them off to do a negotiation, and then they did reflections, and then we came back and did a day talking about negotiating, and if something like that would be enough, then it could come in another course that at least touches on the principles of negotiating, but that makes it a somewhat vague line to establish. So I'm just trying to raise possibilities, like the single course on negotiating in 2 of the 3 schools, or a difficulty in 2 of the 3 schools.
So what I'm hearing is, I'm just hearing that there's a lot of issues with like the opportunities to complete something, and so we're starting to talk about less and less robust sort of opportunities to get a little introduction to some basics of negotiation theory. And I'm not sure that that's like assessing that you've done that for licensing is really like I'm wondering why we're focused on negotiation. I understand the parallel between supervised practice. I think when we go back to our competencies, I'm having trouble seeing on our list of competencies why negotiation has to play such a prominent role that we feel like we must include it. I feel like we got there because we were following what Oregon did and using Oregon as a model. But I think if we were starting with our own competencies and saying this is not an easy thing for us to accomplish, I'm not sure that we would say we need to have it.
I agree. And I think
that sounds.
Yeah, I agree too. Go ahead, Lynn.
Yeah, I agree as well. And I think that it's a message to be brought into the supervised practice discussion about and if they use Curricular as a foundation, which I'm hoping they will end up doing, if it's not added there, then we don't have a problem with it. And I think we realize that it's not as foundational as the client interaction, for instance.
Yeah, I mean, I think two things. One, it's not something that, well, I guess if you're in private practice, right, or solo practice right out of law school, it's something you're going to do. But, first year associates, I don't know that it made the list of things that everyone is going to do right out of the gate. Plus, if we get strong community feedback, I mean, we haven't even opened this up to anybody but this group. And so that may inform the need to develop more curriculum in that area if that's something that we're serious about this pathway and there's just a strong resistance to this program without it, then we have to go back and say, well, then what are we going to do in order to make this work? But I think right now, for us to recommend something that we know we can't deliver on feels not like a good idea.
Yep. I agree with that.
Yeah. And I'll just add that Oregon, which has the requirement, also has it being able to be satisfied with something that is so limited. And an email, an email conversation back and forth with Debbie Merritt, actually, as the person who's running that piece, just a set of messages back and forth, negotiating over some small item. So I think given that they've ended up deciding that they can satisfy it so minimally, suggests that it's not so critical for us to include and then try to scramble to figure out how to include it.
Mm-hmm.
Okay, thank you.
All right.
Well, can we move on to the questions of the timing and and that's I think the main new thing under discussion here, and it was just really the timeline was just kind of me spitballing it, like all the different things we had talked about and trying to put them in a sequence.
Carol, go ahead.
Before you go into timing, and again, this is based on the meeting yesterday, and I don't know if you touched on this or if it was on our list of issues, but there were several strong voices in the supervised practice group for requiring a minimum grade point average of some kind. And it kept coming back to that. And although that's not something I favor, I think one of the things we have to deal with is realizing that those aren't the only couple of voices that are going to talk about that. How are we sure that they have the minimum knowledge if they're, getting, one person said if they get D- in everything, but they're still, they're still a student and they can enter this pathway. I have less problems with that, but it's just something I think we have to deal with. And, one way is to think about that I raised yesterday was I think you can't be on probation in any school and be doing experiential. You can't do a clinic, you can't do a field placement, I think. And if that's the case, but I think then we have to write it in that way and indicate what that level is to ensure that people understand there is in fact a minimum grade point overall GPA, not in any individual class. And I think nobody was really arguing for every class. Well, somebody said they should get a B above a B in every class. Well, we're not going to go there, but I just think we probably should write in something about what the limitations would be just by nature of requiring clinic and field placement work, that nobody's going to be able to be in it if they have below a certain average, and then indicate what that is, just so people reading this understand that and don't just immediately react and say, wait, but they could have a D- in every class and still be doing this, and we can't have that.
Right. Sure. Kate, do you want to walk us through the timeline briefly? Or should we just have at it? Maybe you should talk. Why don't you
Lynn, raise your
summarize?
hand in
Oh,
response.
sorry, Lynn. Yeah. Sorry, Lynn.
I was just going to say, when we talked about this a few meetings ago, I mentioned the possibility of either, I like the idea of just academic good standing, whatever that is at the law school, if it's 2.2 or 2.4 or 2.0 or whatever, or the equivalent of academic good standing in every course. I mean, that feels like more work, but I like the idea of you just need to be in academic good standing in order to be in this program, that every school defines what that means, and that does mirror student practice and experiential learning rules, at least at Mitchell Hamlin, and that feels like a decent thing just to toss in there.
Yeah, agreed.
If it's at all helpful, I can circulate the video from yesterday's supervised pathway meeting to at least a couple of you and put like timestamps of where that conversation happened, if that's at all helpful for you guys.
Yeah, that'd be great, Mackenzie. Thanks.
I also think it might be helpful. I don't know what the supervised practice, I mean, I think maybe this will come up at the larger meeting at the end of August if they're having these discussions in that pathway. But, I think also just like there's a reason why this is going first. And, that I am not sure. Yeah. I think we've had a lot of these discussions and we should continue them, and they should also be mindful of what we're learning through our discussions.
Yeah.
And I kept telling them that should be talked about at the bigger meeting when the whole thing is talked about with the larger group, but they kept coming back to it as though they were reviewing the curricular pathway. So I just wanted to bring that voice in here, not have to deal with it at this moment, but that we're going to deal with that when it comes back again for the bigger meeting at the end of August.
Yep.
Yeah.
Yeah, and I'd rather just anticipate it and include it, and then it's a done deal.
Yep.
The timing and the sequencing. So the idea here would be where we left it at our last meeting, where we left off was the idea that students come back from their first summer after their first year. They've had some exposure to, hopefully they've had some exposure to a clinic or an externship or a legal employment. And they are in a position in the fall to begin thinking about whether or not this pathway would be a good fit for them. We talked about having counseling information sessions going on at that point for students from the bar. We talked about counseling from academic advisors or whoever would be the appropriate people in the law schools about, what this pathway includes. And then a January 1st deadline for applying for the pathway. And that would be a deadline for applying really for the bar. It would open a portfolio in the Board of Law Examiners, system where things could be submitted, and it would have an application fee associated with it. So it would require some sort of, I guess what they say, skin in the game, in terms of, we're providing these resources to support you submitting stuff, and you are actually applying for the pathway. But then it's a question, and then having these windows of review and allowing people to submit at each window. But then the question is, are there interim touch points where their portfolio has to include certain materials so that they stay on track? And if so, what should those be and how early should they be? And that's where the tension arises between giving people enough time to do it and giving people enough time after it's reviewed to correct it or resubmit. And some things, for example, might be fine, but they have to be resubmitted because they're not properly redacted, right? So, we're not even going to look at this. It's not even going to go to the reviewers because you haven't redacted it. So sending it back, resubmit it the next time. So some of these, based on the Oregon experience, that would be some of what would be going on in these review windows.
Mm-hmm.
So I guess I'll just open it with, kind of.
Yeah, and maybe specifically, if AJ and Tom want to comment on the timeline, does it seem feasible? Does it strike that balance properly strike the balance that Kate's talking about? AJ, if you want to start, please.
Sure. I was going to suggest the same thing.
So
You've got to do the heavy lifting.
Yeah, I thought this looked pretty good. I do have two ideas that we can talk about. I will say, and also an observation, with the final portfolio due in May, I mean, the current drop dead date to sign up for the July bar exam is May 1st. So if somebody is submitting their portfolio, I don't know how much of a concern it is to everyone that someone have the ability to pivot into the July bar exam as opposed to hitting that August window of resubmission or the February bar exam or whatever. But the timely deadline is currently in March. Our drop dead date's May 1st. And then I understand that there's going to be some new things with next gen, and I'm not sure if some of that might actually end up a little earlier, kind of on the scale of weeks, not dramatically so. But so that's just, I think when I talked to Emily about it, her thought was that, we can just have really clear messaging that, like, if you don't have everything in by February and you wait until May, like, that's your choice. And there may be, that may be the result. But that's just the observation. The ideas, the first one, I was wondering if we would want the first optional submission window to just be February of 2L. And I know that they're just applying in January, but some people might have something from the fall. If we're going to be running a whole grading session for the 3L submissions anyway, and it's optional, it doesn't seem like there's a ton of harm. And I just keep thinking about Professor Merritt's comment about how their rejection rate's like 25%. And so, the earlier we can get people, to get that stuff in and have an opportunity, I guess the better. And so I was kind of thinking that, and if we need to put messaging like, hey, this is by no means required. We understand that you just applied, but if some of you go-getters have stuff ready, by all means get it in. So that was one thought. And the other one was sort of related. And this might present more logistical challenges, but I was wondering if we wanted to require just one written document by that May 2L submission window. And it could be anything. I don't even care what it is, just to get someone to go through the process of redacting something, filling out a cover sheet, figuring out how their portal works, getting that submission in. Because again, that way I think we have a lot better odds of that August stuff all being compliant and getting graded. And I would hate to have too many people submitting those 3 pieces in August and having them all sent back. And then they're just behind, and it's just catch up, and it's a really compressed window then. So those are my 2 thoughts. And
AJ, I guess even when I was forgetting the dates, and I said January, April, July. Do you think? I mean, there's no like May, August, November, February. It isn't set in stone. So like if it would be better to move it up a month so that last submission window has an opportunity perhaps to be graded, or they have an opportunity to May 1st.
We'll have to think about, I'll have to think about that. And I'd probably want to touch base with Emily and just kind of talk through that more in depth because, we'll be simultaneously grading the February bar exam. And then if that's the timely character and fitness deadline for the 600 people who are submitting to sit for the July, it's an incredibly busy time. The spring is kind of when we get just flooded with a ton of stuff. So February actually strikes me, it's as a maybe slower time because it's before all that other stuff hits. But yeah, we could certainly talk through that a little bit more and see kind of what makes sense, what's feasible for us. But if we're doing other bar exam grading at the same time and getting all that stuff in at March, April can be kind of busy. So
AJ, if I could ask, is there any way to calculate what the time, like the time per review of each document would be to get a sense of what the time commitment is and what the reasonable turnaround would be to notify students that something is not qualifying?
I don't know. I think we'd probably want to hear more from Oregon and from Debbie about those sessions, because this is going to look a bit different. So bar exam grading, we get the graders are assigned one question. They read the question, they read the analysis, they get a rubric, and then they run through 200 of the same essay, right? Each of these is going to be like a bespoke assignment that somebody did for somebody, and they're going to have to kind of get up to speed on the background through the cover sheet and do that. And so I would think each one is going to take significantly longer than grading a bar exam essay, but collectively, I don't really have a good sense for what that looks like. But I mean, Oregon probably could give us some information about that.
What I remember Debbie talking about was that having these grading weekends, where all the graders, where they divide up the work. They have two people reading each written submission. They have these, they assess them separately, and then they come together and they do a reconciliation if they come up with different assessments, and they have them meet together. But it's sort of over one weekend that they do the portfolio reviews.
Yeah, I will also say that I think stems in part from their bar exam grading process. I think they've historically done sort of a retreat type situation for that, whereas we kind of load everything into a grading portal and give people a period of several weeks to kind of go through all the stuff individually. And so in terms of format, I mean, I think there's multiple ways you could handle that, but like that, I think that was in part built off their bar exam grading process, and ours is fairly significantly different. So that would be something we'd have to talk through as well.
Mm-hmm.
Yeah, I would add that I think if I can, I think that grading these things in some ways will be faster, judging by how long it took me to grade individual, like little papers that students would give me on a variety of different topics versus exam questions where I'm looking for particular substantive points being made. It might be a faster process. I do think it's right that because they do this different grading process in Oregon, we'll have to calibrate it differently, but also I think we have to build in some that norm setting exercise that Debbie does at the beginning of those weekends with the graders. I think we'll have to build that into the process of preparing people to grade through the portal. So that just adds a little bit of time, but we just have to remember that has to be part of it as well.
Yeah. Ben, you've had your hand up.
Yeah, so I just initially agreed with almost everything AJ said in his first comments. And one question was how much concern people have about students getting to the end, and if they don't have something. I have a lot of concern about that, about a student being in a situation where they haven't met this, but then it's too late to really invest in to get ready for the fall bar exam and so forth. But on the other hand, one of the skills we're trying to evaluate, which I think we said early on is really hard to do, is kind of the time management and project management and stuff. And that's kind of what this process is. So getting through it in itself kind of speaks to that. And if a student is not able to do that, that also speaks to that and is a reason maybe that it doesn't work. I mean, it still puts the student in a bad position, but as far as evaluating that, it's kind of on them, I do think. One question I had, though, is I like the idea about moving one up to May too, to kind of get them a sense of what's required and get that process started. But students have a chance, as I understand, if what they submit doesn't pass, to do a resubmission of that. So is the thought process with these timelines, you have to submit something in each of these categories, the categories with the X by this date. If you fail it, you can resubmit it in the next cycle. But if you don't submit the minimum, you don't at least submit the minimum, are you out of the program? You kicked out of the program at that point? So for instance, if we did do a May 1, I love that idea, but if a student for whatever reason just hasn't had that class or that experience yet and able to do it, are they out before it even starts? Which maybe is fine if it's going to make it logistically really hard for them anyways, otherwise, but
Yeah.
I don't
Lynn,
know.
I forgot what I was going to say because I got distracted by the last piece, but I was thinking about the bar exam. I really started with this passion that if a student wasn't going to be successful, that they have to be able to pivot to the bar exam. But now I'm leaning more toward Ben, like if we give them every opportunity to be successful and have an outcome before the bar exam happens, then it's almost just like the same consequence as failing your first bar exam attempt, in which case you just take the next bar exam available, right? And so I'm kind of like of two minds about that. I think as long as there is a path for the very organized student to complete things in the same time frame that their colleagues who are taking the bar exam would get the feedback or whatever, then that feels like an equitable chance for people to demonstrate competence. And if they don't, or they don't get it together, okay, well then they just take the next available bar exam, and it's not like this extra punishment, I guess. But the one sort of misgiving I have about that is the pilot nature of this, and maybe we have some kind of like more lenience for this first group, because like if the graders turn out to be super harsh and it like nobody gets through, that doesn't feel like a super good marketing tool for the next batch of people to come through. And so I guess I don't know quite how to square that, other than to have a time frame that at least allows the enterprising student to be able to apply by the May 1 deadline. If they do everything right and they still don't have everything done and they want to pivot, but I don't quite feel so sorry for the folks who don't have their act together and maybe just don't submit quality work, and that's different. And so I don't know how to put that into the rule, but I guess I'm thinking about that in the timeline sense, that I do think if we could get a possibility for somebody to do it right and still have the opportunity to pivot, that wouldn't be the worst thing.
I feel like there's, I would say, I feel like there's the way that the timelines are set up, they've gotten feedback on at least every component at least once, before that May. That's, I think that's left is like the second of something, like the second written legal analysis of at least 1,500 words, the second one that involves original research, and the second client interaction, the third PR journal. So they will have been required to submit at least one of each of those things up until that point. I mean, I guess the biggest issue I see is that we are requiring a more substantial written legal analysis. It could be the same thing that has both 1,500 words and original research, but it's the kind of thing that's most likely to get knocked out, I think, by the reviewers. So I don't know.
Yeah. My thought on this,
Can I
I was just going to say, Carol, my thought is it's similar to Lynn. I think there are two benefits, frankly. One is the students themselves, in terms of having, I don't know, let's say a tough love approach to this, where, the deadlines are pretty strict and we want people to know as soon as possible if this is not going to work for them so they can pivot. And I think that's ultimately in fairness to the students. I also think as a way to, let's say, market this or sell this to the broader community, some of whom will be skeptical of the whole effort as, being kind of an end around the bar exam. And if we allow a lot of opportunities to string this out, that's, I think it's going to make the whole project vulnerable to that criticism or that critique. So I'm definitely in favor of the, giving them every opportunity to get the work done as soon as possible so that they can pivot if it's not going to work.
We could also say that they don't like this is their application for the Minnesota bar. And so if they want to take the bar in July, they need to withdraw in May, and like make a decision, like either, I mean, they have the option to submit all their stuff before. They would be encouraged to do it. If they're waiting until May to submit their last stuff and it doesn't, then they've got the summer to complete this pathway. And if they still can't do it, then they can take the February bar. You know, like it feels to me like you could say if you're on this pathway, you can't concurrently apply to take the bar exam. I don't know what people think of that, but it feels like, you know, make your choice. And there
right.
is an opportunity. You will have had plenty of requirements to submit every type of thing in this portfolio before that May deadline for applying for the bar. So
Yeah,
I don't know.
yeah, sure. Carol, and then Dave.
Sorry, yeah, sorry when I interrupt. I can't.
No,
see
no,
people's
don't
hands
worry, don't
raised, so
worry,
I can't
don't worry.
tell. Two thoughts. One, I'm a little concerned about this really tough love approach, partly because we're creating something with so many aspects to it, and we're, you know, as we get it up and running, realize that we don't know exactly how much burden this will be on students to be able to do this. But I also wonder, one of the things and I can't remember the timeline on this from what Kate put together, but if it is a curricular pathway, and the coursework, the experiential work, a lot of it has to be done during law school. But we had talked early on about, is there a possibility of completing this under supervised practice pathway? Well, that won't be a possibility, because, at least initially, because that's going to take a while, even if it is set up to set up. But whether there an opportunity, if there's a certain number of documents that have to be in the portfolio by the time of graduation, but that some could be done within a designated period of time afterwards, so not leaving them any number of years they wanted to complete it, but some ability to not just August things that were done during law school, but potentially things that were done in a practice situation after graduation where they're not yet licensed. So just floating that possibility. The other thing I wanted to mention was, when we think about timelines.
Carol,
Yes.
the timeline, the last August submission possibility is after graduation.
Right, but whether we want to extend that even further, say to a time after that where they might, yes, they could have a summer job, but because they're not studying for the bar, I just the idea of maybe August of just post-graduation as not the last possibility, but that it could be a little bit after that, to give a little more time to a certain number of submissions. Want to be sure a lot of it's done during law school. So just thinking about that last one. The other thing I wanted to mention on timeline is to be careful about the May deadline, only because I know whenever adding any what students have to do when they're close to exams is really difficult. So just to be mindful of whether that deadline will fit with the student schedule in the end of the semester.
Mm-hmm. Okay, David, you.
Yeah, a few observations here. One of them, and I think I raised this a few months ago. I've always been a little concerned, and this is kind of getting to our tough love issue here, that we're making the requirements so difficult here that we're either setting people up to fail, or that we're going to discourage so many people from taking this option, that either it fails, or again, the process, this whole process fails, or again, that we make it so rigid that we basically undermine the whole process of what we're trying to set up. That's sort of one observation. I think we're sort of coming back to it here. The second thing, kind of a story here. Back when the pandemic hit, and I was on the professional responsibility, committee for the MSBA, and there was a proposal before them to support, from some of you might remember, the students were asking for just that first year a degree only admission to the to practice law in Minnesota, given all the conditions going on there. And the court eventually rejected it. But I also remember talking to other people who are on that professional committee, professional responsibility committee, and there was a sense, this I kind of gets back to something what Steve was saying here. There was almost a sense in which all of the other people on the committee said, kind of like, well, suck it up. I had to take the bar exam. I can go through it. You can go through it here. And it gets to Steve's comment here about who's our audience here. Are we trying to persuade the general public? Are we trying to persuade lawyers? I'm just trying to think of who we're trying to persuade with all this. Maybe it's the Supreme Court. I don't know. And then the last thing I want to throw in here, I think we've talked about this before, but I can't recall now. Help me out here. Are we making this recommendation as kind of like a beta that says we'll try it for 5 years or something like that, and then reevaluate it? Because if we don't make it clear that this is just sort of an initial beta or test to see what happens, and give us the sense of permanency, then I think we engender more objections to it than we otherwise would have. So just a variety of observations here.
Yeah, those are good points, David.
Yeah.
Maybe that gets a little more to the question of what's the process from here, I suppose.
Yeah.
But I've had the same thought about, it's a little it's a little easier to convince the audience when you say it's a pilot, and we'll evaluate
Yeah.
and change if we have to. And I think that's the approach that we're taking, but maybe we need to be more explicit about that.
Yeah, I want to explicit, but I'm also just concerned a little bit about, and I don't know how to deal with this. You folks tell me also here. Like I said, going back to the pandemic, it was kind of the way they were sort of the other attorneys on the committee were approaching it. It was almost like the fraternity hazing approach, if you know what I mean, like that. It's like I had to go through the bar exam. I had to suffer through it, et cetera, et cetera. And so here we're kind of caught with a dilemma. If we have too many rigid requirements, we maybe set up this program to fail, but we don't have enough requirements on it. There's going to be people who are going to say, well, this is just a way of, I don't know, people end running around the bar exam, and I had to do it, so they have to do it. So I think somewhere in, whether it's in our introductory statements or something like that, but just overall our design of it, I think we have to address those if I can call them philosophical concerns or political concerns. I'm not sure which phrase I'm looking for here, but I do remain concerned about the idea of too many requirements, setting it up to fail or making it so difficult that the grading process and everything just becomes, well, it basically dissuades people from trying it.
Yeah. Okay, let's see. I'm not sure what order folks have raised their hands
Lynn,
in,
I think
but
they're in-
Lynn,
Yeah, I think
Lynn,
they're
you're
in
first,
numerical
then-
order,
Yeah,
but I
Lynn,
have
then,
one
and, Kate.
observation and then an idea. So this reminds me a little bit of when we launched the hybrid program, then hybrid program at Mitchell Hamlin, right? And it was a little bit of a pilot. We had just a handful of students, and we learned very quickly that we had to pivot and we had to be slightly flexible and we had to be sort of entrepreneurial about like what we thought the requirements were going to be and then the actual like implication of that. And so I think calling that out, David, I think you're exactly right that this is a pilot, that there may need to be some flexibility in this first iteration so that we don't inadvertently like disenfranchise everybody who wants to be part of it. And I wonder if there's an option for something like conditional admission. So this is a thing, it's usually tied to character and fitness, but is there a way that we could say, okay, you've gotten 85% of your portfolio done, you're not ready to be fully admitted and out on your own, but there could be, I mean, that's a process the bar already has in place. Could we leverage something like that where you're conditionally admitted and you need to have, some supervision or some sort of thing? I don't know if that would work, but it just struck me that that's a concept that exists already, to Kate's point about not reinventing the wheel in terms of how we, attach this to other things that are already in place. Those are my thoughts.
Yeah. Okay. Thanks, Lynn. Ben.
Yeah, no, I really like the idea of having some kind of tail at the end of it to allow students to get that final piece or two in, because I'm just imagining a student at the end of their sixth semester, they have two pieces left and they've gone through all the work to get to this point and they've paid a fee already to get to this point, and then trying to decide in May, do I withdraw from the program and sign up for the bar and sign up for the bar prep classes and invest in that? Or do I, if I had that couple more months to get that final thing in, that would, and in particular, the students who they did everything they could and they planned it, but they just couldn't get into that last externship or clinic or whatever that they needed. And then I could see it coming back with a lot of anger towards the school of, you didn't provide the resources, and they feel misled, even though at the front end, I'm sure we'll have all the disclaimers and language that, we're not guaranteeing it. And also, if they really are there, they're really ready, they just need that one or last two piece, it seems really unfair to say,
Mhm.
you're otherwise good, but you got to go through a whole nother process. So whether it's a conditional thing, I like the concept of that maybe, or whether it's just allowing them to get their last one in August and they have a, clerkship that they can have a supervisor to help them with that, whatever it is. So.
Yeah. Okay. Kate.
I have an idea. So first of all, I don't think that this is terribly onerous in that compared to the bar exam, you study for it for several months, you take it, and then you wait several months to find out whether or not you passed. It's an all or nothing shot, and you study for it and you take it and you take your chances, like basically, like you hope you're going to pass, but you wait. It's a several month process, and it's all or nothing. This is saying, give us a few things. If they're not good enough, you could resubmit them 3 months later. And if they're not good enough, then you can resubmit them again. If they're not good enough, you can resubmit them again. We're adding 1, 2, 3, 4, 5. We have 7 submission periods where they can continue to put materials in their portfolio. I think having deadlines where you say there has to be a certain number of things. And so I think being strict about the deadlines is a good thing. I think being too lenient about the deadlines is not a good thing. I think the framework is lenient. The deadline should be strict. If you miss your deadline for applying for the bar, it's not like you can say, "Oh, sorry, like I've decided a month later I can do it," or it feels like part of being a lawyer.
Yeah.
But I do also think that it might be possible with these interim deadlines where you say you need to have these many things in, that if there's one of them that they haven't been able to do, that we could have a process for them filing sort of a motion for extension, like, or saying, or an application for extension for a particular item, stating reasons why they can't complete that item. So the submission has to either be the client interaction or an application for an extension for 3 more months to get that, to the next grading period, to get that in, that they can use. So I think that would more mirror what good practice is. Like if you have a deadline, you have to either meet the deadline or ask for an extension with the court or whoever, and give your reasons why. And then sort of keeps it on the track of professionalism, instead of having to make these decisions like someone at the very last minute. I was going to submit these things in February, but then my grandfather died, and I had to go to the funeral, and I wasn't able to get internet connection, and like whatever,
Yep.
Lynn knows. We get
Yeah. Right.
So but it would be like, okay, then fill out this motion for extension and explain why.
Yep. Okay. I'm cognizant of the time. We got 15 minutes, but let's go to AJ and then David.
Yeah, I was just going to say, kind of like, I guess similar to Kate, I think that the benchmarks are good, but we could talk about the consequences. Like, I don't think this has to be an all or nothing. You get kicked out of the program if something isn't in by a thing, but having these earlier benchmarks to get most people getting more stuff in, to get evaluated, get feedback, and figure out if they're going astray is good. So I think that her point about that, I guess that'd be my approach as well. And I was just going to say on the conditional admission piece, I would look to the supervised practice rules, actually. I mean, we have the postgraduate supervised practitioner piece. The conditional admission thing's that's going to do a whole boondoggle that I think administratively we don't really want to try to shoehorn that. But I would just encourage everybody, if you want to do this kind of add-on piece, look at the supervised practice rules and the post-graduation opportunities there, because that would be much easier to kind of be the completion piece, I think.
Except that even with supervised practice, the person has to take the bar exam, right? So we'd have to have a different kind of carve out, I guess. And that's where I was thinking about the conditional admission has the word admission in it. It's like, you're admitted if you do the following things. And so supervised practice is just a bridge to passing the bar exam. So we'd have to marry those two
But when you're condition
somehow.
admitted, you're fully
like,
licensed. You're fully licensed day one, unsupervised, like whatever. And I mean, I guess I'll just say we get all kinds of people with these odd miscellaneous requests about, oh, I haven't signed up for the MPRE. Can you conditionally admit me so I can just, I mean,
yeah. And so maybe I'm using
I don't
that
really
in the
want to
wrong
open
way.
that Pandora's box. I guess I would
Yeah.
much rather take a look at whether there's a supervised practice edit that like builds this program into it than trying to do the conditional mission piece.
Yeah. And I guess that's what I was getting at, AJ, is like not straight up supervised practice where then that at the end of the day, if you do these things, then admission would happen, not it just delays you until you finish the bar exam or whatever under the current system. Yeah. So I think we're talking about the same thing. I'm just probably using conditional admission the wrong way.
Sure.
Okay. David.
4 quick observations. First, I agree with Kate and everybody else here about the deadlines. I teach both undergraduate and law, and one of the things I have to spend a lot of time with my undergraduates teaching is what deadlines matter. And part of I think what we're teaching in law school also is that no, Tuesday means Tuesday, not Wednesday or Thursday to file paper. So no disagreement there. Second, just in terms of like burden, we've talking about the burdens on students. Again, as our discussion was pointing out today, we're asking a lot of stuff of law schools too, in terms of what they're going to have to do. So we need to be thinking about also that. And then eventually, if this is going to work, what about out of state law schools? How's this all going to kick in terms of something? And unless we're saying we can somehow figure out only apply this to in-state law schools, I don't know. And then this may be my last observation here is that I've actually been assigned to some people who've been like conditionally admitted, but they've had like some ethical issues or something like that. And that's kind of a different, AJ could speak to that too. That's kind of different, than what we've been talking about here. And it's also very, very labor intensive, where I meet with people like a lot, to talk to them about like ethics issues like that. Just quick observations.
Mm-hmm.
Yeah, I think that was my mistake. I'll retract that suggestion.
When there's an opportunity, can I slip in?
Go ahead. Yeah, you've got it now. Okay, Carol, go ahead.
Okay. Let's see. I got to keep in my brain what. I like the supervised practice. This avenue. The kinds of things we're talking about. There was one. Okay, I'll make the one point I can remember, and then I'll see if I can remember the other point. There's been a couple of comments about references to resubmission. One of the things that is true in Oregon, and this is something we have to decide, and I thought we had talked about it, but I can't quite be sure. In Oregon, they do not allow people to resubmit the same document just fixed up, and I thought we were heading in that same direction. You can submit a replacement document for anything that's rejected or doesn't make it because it wasn't redacted. But I think we want, I'm a little more on the tough love side on this. Make sure your document is good the first time. And if you do something that's not good enough, we encourage people to say, well, maybe this will work. I'll fix it up later if not. And I don't think we want to do that. I think we want to say a new submission to replace the one that was either rejected or didn't make it through for whatever reason. The one counter to that is in the law school environment, it may be harder to have the opportunities to create a new document, but I think this is something we have to be clear about, whether we're talking about resubmitting a fixed up same thing, or we're talking about a new submission to replace the one that was not accepted. And then I can't remember the other point now, but I'll click back in if I remember that.
Sure. Kate, do you want to speak to that resubmission point? Yeah.
Yeah, I think that's great. When I was actually writing it, I was like sort of floating back and forth in my mind between what are we asking. So I'm glad that Carol raised that point about like we need to clarify that. I guess I would say that at the screening stage, like before it goes to the graders, if the reviewers say, that's not properly redacted, we can't send that, because we can't even send it for review because you haven't submitted in the right form or whatever, that could be fixed and resubmitted. But that if it were reviewed and found to be insufficient, on the rubrics, that it would need to be a replacement. I don't know if that's, that, at least that's
Yeah,
what
that-
makes
Mhm.
sense. to
Yeah.
me.
Yeah, that makes sense to me too. And also things may be rejected because they missed the deadline. I mean, they do that in Oregon. I'm sorry, you were 10 minutes late. It doesn't
Sure.
get submitted because they have to have everything in place. That one could be resubmitted too because it's not rejected on the substance. That makes perfect sense.
Okay, good.
Oh,
Yeah,
whoops. The other
Yep.
thing I was going to say, this goes back to David's comment about who are we talking to. The the communication subcommittee of the supervised practice pathway group is looking at creating communications for all of those. So, you know, we are talking to all of those groups. We're talking to the Supreme Court, we're talking to the public, we're talking to other lawyers, and the communications group is thinking about that as they're not just really a subgroup of supervised practice, although technically they are. They're also thinking about communications with respect to curricular pathways. So I think just the answer is yes, and we're thinking about the fact that it's all those different audiences that are out there that have to be, the information has to be it's going to be the same program, but it will be articulated differently to different groups perhaps, and the questions asked of them will be different. The other, there was, and I do think we need to, and I don't know whether this was someone other than Kate and me who were going to do this part, but I think we need an overview document other than the one we have, which lays out the program. I think perhaps we need something that explains, or maybe Steve and Lynn were going to do that kind of explains the point, the purpose, the theory, the reason for doing this pathway. Because I think when it's out for public comment, it has to have that overview purpose document, and the supervised practice will have to do the same thing, and they will be a little different, but just what's the concept of why this will produce people who are competent to practice law. I think we have to have that piece when we're ready to roll it out for more public comment.
we totally agree.
And I had that question last time, and I had asked, I think, Carol, the communication committee. I guess I was confused because I understood that was the role of the communication committee, like sending out pieces to bench and bar and putting FAQs on the bar examiner website and whatever. And so I didn't want to duplicate effort if that was happening. And so I guess I'm confused about how much of that is already in the works.
Yeah, we are doing FAQs, and there's a bench and bar article in process, and there's outreach to various groups that's going to be calendared of going and talking, and there's a one pager, and there's stuff, there'll be talking points for all of those audiences. This piece, and I will talk with Leanne about this part, about who might do this part, which is the broader. It's not just let's talk communications out, but we don't want to duplicate it. I think that this proposal has to have a front piece that contains that overall explanation. But you may be right, communications will do that. I'm not sure it's on our list, but I'll talk with Leanne about that.
Yeah, I had it on our list and on our timeline, and then I heard from Leanne that this other group was working on stuff. And so I guess that's a critical piece, because I agree it does need some context setting, like how did we get here? But I just want to make sure that we're not all trying to accomplish the same goal. And I don't know quite how to get the answer to that question.
I think what we could do,
Yeah.
I was just going to say, Carol, if you can talk to Leanne about it. I think we wouldn't want to reinvent the wheel, but we've got a separate audience in addition, I think, which is the law faculties. And we the communications committee may have may be appealing to them as well, but I think those of us in this group have some specialized knowledge of that audience and what they're going to need to hear and what's going to make them feel comfortable, in part because, as AJ said, we're asking them to do some of the work here. So it's not just philosophical, it's labor oriented. So AJ, and then we should figure out what are the next steps.
So just real quick, I was just going to say, I also perceive some sort of ambiguity in the resubmission stuff that Carol was talking about. And I was thinking maybe the best solution would be to have two sets of terminology for things that are graded and not graded. So not just insufficient really has two subcategories. There's administrative defects that it got rejected, and then there's stuff that didn't pass grading. And so we could have, deficient versus not qualified, and we can have resubmit versus replace. And if we kind of develop sort of terms of art that kind of cover both those, I think the procedure will be clearer for people. And then when we're writing up FAQs and procedures and instructions for people about what their next steps are to solve the problem, it'll be easier if there's kind of two sets of stuff. So that was my idea.
Yeah. Okay. All right. Next steps.
Our next meeting is with the full group.
Yeah,
We don't
it
meet
is.
again.
We don't meet again. Kate, do you have Kate and Carol, who've been doing all the heavy lifting on this? Do you would it make sense for you to revise the time frame and maybe the overview document that you've done in light of this discussion today, to make a few things clearer, or maybe adjust the dates or whatever? If you can do that, I don't know, within the next week.
Yes, and I would say yes in terms of the timeline thing. I might take out, might just make it, the timeline thing is probably more of an appendix, but to write out in a little more detail, a detailed description of the application submission process, and clarify some of the things that we've talked about today, especially this last point that was just made by kind of Carol and AJ about what, like the steps in review. There's a screening step, and that then if it doesn't pass the screening, it doesn't even get passed on to the graders. And maybe put in this idea, if people are okay with it, with if there's something that you can't submit, you haven't had an opportunity to do by enough, you can file an application for extension for that piece. But all of that has to, for every required piece in the portfolio, you either need to have it or you need to have the application to extend the deadline. And then, I guess just see, those would be the ideas that I would sort of work into more of a narrative.
Right. Okay. And then
Hand up.
AJ, go ahead.
Yeah, I guess we didn't really have time to talk about the application process or fees, kind of the overall structure. I know Emily had some thoughts on that. I don't know. We're kind of tight on time. I don't know if you want me to share some of that or if we want to take that offline afterwards. But
if people can stay on a couple of minutes. Yeah.
I have to go. I have a hard stop at 10, but maybe Emily, you could stay on, and then maybe Emily could draft up whatever her thoughts are, and then we can incorporate those. I think that we definitely want that context for sure.
Right. And then before you do that, AJ, and while you're still on, Lynn, so the idea is we're going to get feedback from the larger group on the documents that Carol and Kate are working on. And then are we building in time to then make whatever adjustments are necessary before the finished product is sent out? Is that right? And how much time are we thinking there?
I think that's, and other people may remember details more, but one of the things about the communications piece is that I think this is geared to, that's an October issue of Bench and Bar, and from that point is where the communications committee is talking with various groups and rolling. I mean, there's just the public comment on the website, but I think we do have time because we're talking about something that will hit the public in the fall in a way that has a lot of different avenues in to hear about it. And so my sense is that we would have time, and there's an expectation there would be potentially revision and refinement after the meeting the end of August, and we have time to do that before we finalize it for the next stage.
Okay. AJ, do you want to, and if folks have to drop off, that's fine, obviously, but AJ, if you want to give a quick summary of those points, and then we can get more info offline from.
Yeah, so she had kind of envisioned this as we would bifurcate part of the application process because it's kind of a 2-year thing. And so I think what she wanted to, she was thinking it might be helpful for people to have off ramps. So like if the feedback they're getting, it's not going well, to have, be able, and so, basically, they would apply that January 1st of their 2L, and there would be a fee for it, but perhaps like half of whatever the total fee is. And if, maybe really early on, somebody in the first grading session is like, what, this just isn't for me, and wants perhaps like a partial refund thing or something. I mean, the details we'd have to work out, but then I think she was anticipating that would then be a separate, like an application for the program that is separate from an application for admission to the bar. And that then in that 3L January, when they're submitting the character and fitness thing, that would be the second half of the fee, and that's your character and fitness application. That's your application to the bar. That will actually put in our application management, like you have a live application for admission to the bar database rather than a separate database. And like those pieces would sort of give people the opportunity to, if after the first year of the program, they want to switch to taking the bar exam or do something like that, it's not the, full fee up front, no refund, kind of giving people those opportunities to incorporate that feedback and and go from there. I think she was going to check in with, some people or some of our financial, I don't do budgets, and so I can't speak to like actual fee stuff. I think she was anticipating that this would require a higher fee than the bar exam application, but I don't have any specifics, in terms of magnitude or amounts or anything like that. But I guess that was kind of the structure we were looking at. And so like the second year, the 2L piece, or well, the second year piece would be in sort of a separate database, and we would have a portal for people, to do the submissions and things like that, but it would be just for that. And then the full application piece would come kind of in that winter 3L. So I don't know what everyone's thoughts on that are, but it's sort of just, it was kind of her thinking in terms of giving people the ability to adapt based on how things are going in a way that gives them options.
Sure. Kate, did you have?
No, that's really helpful. I guess what I will commit to doing is just writing a bunch of this up and then circulating it. And you can, like, I think Carol and I were working in a Google Doc, but it has become really hard to translate that when it converts back to Word, like all kinds of weird things happen with the formatting, and it just, I think it's got a lot of embedded comments that it's hard to delete out of the Google document. So they kind of like come along and in the metadata somewhere, I don't know, but I think it's easier to just work from the Word document at this point and circulate that and have people use track changes on it. But I will do a first run through of trying to write up in narrative form what we've talked about.
Yeah, and I just wanted to like kind of inform everyone, and if anybody had any strong feelings about that sort of overall structure, I just thought that'd be good to get out there, and but I don't know, it made sense to me. So
yeah, that makes sense. I think the other questions that are out there will be like, oh, well, what if someone comes along in January of the third year and says, oh wait, I want to do this, and well, I've got a bunch of portfolio materials I could submit, like whether we say sorry, like too late. Yeah. Probably so.
Yeah.
But certainly that won't be an issue for the pilot. The pilot will be.
No, the pilot will be different. Yeah.
Can I go back to that pilot question just briefly? I think it's right. There are two ways to articulate that. One is we're trying this out and we'll see if it works, and the other is what other jurisdictions have done, which is say, we're instituting this, and in 2 years or whatever the time frame is, we are going to collect data and evaluate it, and then come back and consider, and not reconsidered, but not. I tend to prefer we're putting this in place, but we're going to establish a schedule for evaluation. Oregon is doing that now, but it takes time to collect that data and then evaluate it and figure it out. And I think we have to be sure that we have it in place. This is a long time frame for students too. We've got to have enough time to do it and get to the end, and then we evaluate it, and then we see whether we want it. So I think we can talk about a preliminary, that at the beginning it may not be open to everybody, and that it will be evaluated, that we will collect data about how it's working. But I would rather see it put in place with an evaluation process in place rather than we're going to do this as a pilot. We'll think about whether to go forward, because our mandate is really to do it. And the question is how to do it effectively. And one of the ways to do that is to try it out and then tweak it before you consider it permanent in that form. So it's just articulation, I think, about how we're going to go about this.
Yeah. And I don't know, Carol or Kate, maybe you can, put language to the effect that you've just articulated, Carol, in the overview document, so that people are aware of that. This is we're doing this in a couple of stages, but we will be evaluating it. I think it's a good idea.
And that will be part of the recommendation that the group will ultimately make, whether this should be a pilot, quad-pilot, or if it should be something more along the lines of what Carol had described.
Right. David.
And those, again, that's all
sorry.
recommendation.
Yeah. Quick topic.
I'm sorry, I just meant to say
No, that's
all recommendation for the court to ultimately decide.
Yep.
And then, of course, if we're talking about whether it's successful or not, there's sort of two benchmarks here. Benchmark number one is how many people get admitted without taking the bar. But the ultimate one is, which I don't know if we can assess easily, is 1 year, 2 years, 5 years, 10 years down the line, are they good lawyers? And that's just a different question for a different day.
Yeah.
Okay.
Yeah, we don't figure that out for the people who pass the bar.
Yeah,
so
right.
That's true.
Brought before the, on discipline. So yeah.
That is true.
Exactly.
But that IELTS is doing, they're doing a study themselves, and we actually need to pay attention to that. They are not, I don't know exactly how they're doing it, and whether they actually can do it now, but they are looking to explore alternative pathways and how they're working. They're starting that project now, or beginning, or talking about it at least. And so we want to tip into that, because they may very well be an ally for doing that evaluation. And it may include that longer term, what is it like out in the world where they are being lawyers? They did that for the New Hampshire program for Daniel Webster, and did a great study that showed how much better those folks were as being lawyers in many cases. And so I think we don't have to invent the wheel on this. We should tap into what they think that they're going to be doing in the future, and maybe even maybe even see whether they want to work on that evaluation. But of course, it's going to be several years down the line because we don't have it in place yet.
Yeah. Sorry, Carol. Who's doing that evaluation?
That's IELTS, the IAALS. It's the same people who did the Building the Better Bar study.
Okay.
And
Also,
Logan Cornett is on our, Logan is on. She's at IELTS, and she's on our bigger committee. So we have a connection there.
Great. Okay.
Access Lex is another organization that might be interested in doing that kind of review.
What was it, Kate? Say it again.
Access Lex.
Access Less.
Is it another organization that might, not just our state, but other states as well.
Yeah.
And they fund things too sometimes. So
Cool. Okay. Thanks, everybody.